So we have the distinct honor of having this incredible roundtable here, and what I think the structure that will follow is that we'll have a brief set of introductions, and then a set of Q&A for our panelists, and then just an open conversation that we're hoping to have following that. And so let me just begin by introducing first Mr. Lalit Bhasin, who is president of the Society of Indian Law Firms and managing partner at Bhasin & Company. Mr. Bhasin is a prominent lawyer within India as well as globally. Many of us know him for many years. He was awarded the honorary membership of the International Bar Association in Melbourne in 1994 for outstanding service to the legal profession. He is also honorary Secretary General of the Bar Association of India. He was awarded the Plaque of Honor by the Prime Minister of India in 2002 for an outstanding contribution to the rule of law. He is the executive president of the India Law Foundation. According to Asia Law Profiles, Mr. Bhasin is the high-profile, quote, high-profile advocate and litigator, and continues to be one of New Delhi's leading lawyers and is part of one of the country's leading litigation firms. Mr. Bhasin is well respected for his leadership abilities in the legal community, and apart from litigation, he has a wonderful reputation for being a corporate and commercial lawyer, and his firm has recently joined the list of firms involved in the privatization process. Bhasin & Company currently maintains offices in New Delhi and Mumbai, and has 28 associates. Our second roundtable panelist is Ms. R.V. Anuradha, who is a partner at Clarus Law Associates, which she founded and co-founded in 2007. Prior to this, she was a partner at the law firm of Anuradha. Her focus areas include trade law and policy, environmental law, carbon financing, and climate change. Her work relates to both transactional practice as well as policy advisory work. And she is one among two lawyers from India recognized by the International Who's Who of Trade and Custom Lawyers in 2009. Anu graduated from the National Law School of India, Bangalore University in 1995. She has a master's degree from the University of London, where her focus was on law and development and international environmental law. And she has a degree from New York University School of Law, where her focus was on international economic law. Our third roundtable panelist is Mr. P.M. Devaya, who is a partner and general counsel of Everstone Capital Advisors. As the general counsel for this company, Mr. Devaya leads the legal teams on due diligence, investments, and monitoring for both private equity and real estate investments at Everstone. Prior to joining Everstone in 2007, Mr. Devaya had over 17 years of experience working as general counsel for ICICI Ventures, and he's also worked with Carlyle Group and BPL. Which is a leading telecom company. He holds a Bachelor's of Commerce degree and Master's of Law degree from the University of Mysore. Finally, the person that I'm going to be introducing before I turn it over to the Vice-Chancellor is Ms. Pratibha Jain, who is the founding partner and head of the Delhi office of Nishit Desai Associates. She heads the banking and finance and regulatory practice at NDA. Ms. Jain brings with her a breadth of international and Indian experience, having worked in New York, Tokyo, Hong Kong, and Mumbai. Previously, she was president and counsel for Goldman Sachs. She worked at Sullivan & Cromwell in New York, as well as in Tokyo, and in the Hong Kong offices, she worked at Skadden Arps. Her educational qualifications include a BA with honors and an LLB degree from the University of Delhi. She holds a BCL from the University of Oxford, where she was at St. Catherine's, and she has an LLM from Harvard Law School.
Thank you so much, Jay. I have the greatest pleasure and privilege to introduce Mr. Rajiv Luthra, who of course does not need any introduction to this audience. Mr. Luthra is one of the greatest institution builders of our country. He has established one of the most prominent Indian international law firms, the Luthra & Luthra. He's founder and managing partner of that firm. It's one of the largest law firms in India. He has over 25 years of experience in advising clients on a vast range of complex commercial transactions and litigation, including infrastructure projects in India, Sri Lanka, Bangladesh, China, Nepal, and Nigeria. He has successfully handled various disinvestment privatization and restructuring assignments, and has worked on some of the largest mergers in Indian corporate history. He has been appointed by the Government of India on the drafting of several rules and regulations. He has been ranked amongst the leading individuals in banking and finance by the Asia Pacific Legal 500, and has also featured in the Leaders Profiles India Project Finance of the Chambers Global, the world's leading lawyers at Chambers and Partners publication. Further, he has, to his credit, a number of publications in various national and international professional journals and magazines. But on a more personal note, I would say that Mr. Luthra has been a great supporter of our institution. In fact, I remember very well way back in the year 2008 when we were barely acquiring land for the establishment of OP Jindal Global University. Rajiv signed a memorandum of understanding with the proposed to be established Jindal Global Law School. In the proposed to be established OP Jindal Global University, he has been one of the strongest supporters of our university and has been a great friend, and I am grateful to him for his presence. So thank you very much, Rajiv. Secondly, of course, I've introduced Mr. Pandey. I would like to introduce Mr. Siddharth Raja. Siddharth Raja is one of the young corporate lawyers in the country, also a graduate of the National Law School in Bangalore, and has studied and worked on issues related to corporate law in other parts of the world as well. He was also working at O. Melville and Mayers as well as other firms. He is right now heading and founder partner of Samvad Partners. Siddharth has distinguished academic record besides having an LLM in International Economic Law from the University of Warwick Law School, where he was Foreign and Commonwealth Office Chevening Scholar and the Jayanth K Scholar. He is admitted to practice in India and England and Wales. Siddharth has previously been a visiting faculty at the Department of Management Studies of Indian Institute of Science, Bangalore, as well as Jindal Global Law School.
Wonderful. So I think what we'll do is, like I said earlier, what we will plan on doing is asking a series of questions. And I would like to start with our friend, Mr. Bhasin. And we have a microphone right there, so we'll just pass that around as we go through the questions. But Mr. Bhasin, of course, you've been at the heart of this subject on the liberalization of legal services for years. So I was wondering if you could just start off by giving us a broad overview of how you see this issue today in 2016. And specifically, can you talk about the Society of Indian Law Firms' views towards the BCI's draft rules? Now, how you see this issue of reciprocity, especially given how reciprocity has been defined differently, depending on who one talks to. And whether you think an amendment to the Advocates Act is necessary to allow for the registration of foreign lawyers.
Well, you have asked me so many
I have,
questions.
I know I have. I don't get this opportunity often.
I don't want to take the time, you see, of the other panelists here, but this requires, you see, a very long discourse on what has happened.
We have 2 hours.
But you see, what I feel is that the opening of the legal services sector as an issue is no longer there. Because I think everyone is agreed on this, that as a matter of principle, as a matter of policy, we are all with the government when it's initiated this move in 2014, that the legal services sector needs to be liberalized and opened up. So that is not an issue. It was a major breakthrough because for more than 20 years, ever since I have been at the helm of affairs of the Society of Indian Law Firms and my colleague Mr. Rajiv Luthra, who is also the Senior Vice President, along with Jyoti Sagar, who is the Associate President, we have always opposed the entry of the foreign law firms till 2014. And same was the stand of the Bar Council of India, of various bar associations of India. So we were not alone, you see, in opposing it. But then we took the lead, that is of a Society of Indian Law Firms, took the lead in 2014 after some series of meetings and discussions, that very well we have utilized these 20 years to strengthen, you see, the Indian legal profession, particularly the law firms. Therefore, now at this point of time, we feel that Indian law firms are second to none. They can face good and healthy competition from our foreign counterparts. Therefore, they should be allowed to come and practice here. But the issue was how that is to be done. The issue was not whether Indian legal services sector should be opened up or not. That is a closed chapter. The procedure is how do we follow it up. Therefore, in 2015 January, we had a dialogue with the Ministry of Commerce at the initiative of no one else than Mr. Sudhanshu Pandey, who took the lead in that. We had an interaction, and as a matter of fact, the Society of Indian Law Firms, we presented our representation by name to Mr. Pandey as the Joint Secretary. And thereafter what happened was that an inter-ministerial group was set up by the Government of India, in which about 17 other ministries were represented. There the Ministry of Commerce made a presentation which was coincidentally almost identical to the representation which we had made to the ministry, to the Government of India. And we had recommended, and the Ministry of Commerce agreed with us, that there has to be a phased sequential entry of foreign law firms in India. Therefore, now the question is basically about the procedure to be followed, the timelines you see to be established. And as Mr. Pandey also very rightly said in his remarks in the inaugural address, the governance issue as to how it is to be done. Now, phase one, which is very critical, phase one, as the subject has been rightly chosen, opening of India's legal services sector. It is India's legal services sector, how it is to be opened up. Firstly, it is to be opened up by liberalizing the internal functioning of the profession within the country. That is the phase one, that you create that sort of a level playing field, which again Mr. Pandey had highlighted. There are certain things about LLPs. Now LLPs in principle you can set up an LLP, but the Bar Council of India does not permit us to do so. And whereas in their draft rules, they say the foreign law firms can come either in the form of a partnership or LLPs and all that. On one hand, you don't allow the Indian law firms to convert themselves into LLPs. On the other hand, you allow the foreign law firms to come, you see, in whatever form, even as the companies you see to come. Therefore, the first part is opening of the legal services sector, the current status. The current status is, unfortunately, all tilted towards the foreign law firms in the sense that we can't compete, we can't advertise. What they call advertising, we call dissemination of information, some basic information about the law firms in India. Someone sitting in Chicago wants a lawyer in Kanpur, how would he go about it? No, I know my friend Lalit Bhasin, he may help me in finding a lawyer in Lucknow or Kanpur and all that. That is not, you see how the technology is being used, ought to be used to its maximum advantage. So what they call advertising, they don't allow us to have our entries in the law directories. They don't allow us to bring out, you see, our brochures. They don't allow us to have a proper website. So that is, you see, the sort of first phase is, there are so many other issues, you see, which we have highlighted in our representation to the Ministry of Law and Justice and also to the Ministry of Commerce. So I think for the time being,
thank you so much.
this would be place.
Thank you so much, Mr. Bhasin. Now my question is to Mr. Rajiv Luthra. Rajiv, there are a lot of expectations and aspirations from young law students across the country. So what I would like you to briefly articulate is that as somebody who has benefited from the opening up of Indian economy, in which both trade and services could be seen from the standpoint of how law firms such as yours can actually engage with the wider private sector, what was your position on this? What do you really think that we ought to be doing in the next months and possibly a year with a view to advancing what you and Mr. Bhasin and others seem to be already suggesting, which is that in principle you have now agreed to the idea of opening up of the Indian legal sector?
Thank you. you. I'd just like to make one or two quick comments before I answer your question. Firstly, it was very refreshing to hear Ambassador Verma talk about bringing down walls when there is a gentleman sitting in America right now wanting to build walls. So that was quite a refreshing bit. The second bit that I think I should bring to especially the youngsters' notice when Mr. Bhasin, who I follow blindly, said that we were opposed for 20 years. There's a simple reason. If you let the foreigners come in, we were allowed only 20 partners. And if they come in, how can we compete? It's like asking me to run the Olympics 100 meters with Ben Johnson with both my hands tied behind my back and a big steel ball on my left leg. It's not going to happen. So we weren't opposed just for that we were inferior or we were just opposed that the government would not do a level playing field. They would not, and it's not about the Bombay Club. It's not what happened then. So you have to understand why this thing was happening. And it wasn't we didn't make representations, we also filed cases. There is a full detailed report of 2006 of JETCO which lays out the steps. 2006, we're now 16, it was a decade ago. And I spent a lot of hard work on that myself on my own dime. So what was your question, sir?
All right. I knew you would do this. So what I was really asking was, the reason I say this is that there are young people who have great aspirations today, more than ever. From the time you went to law school, and even I went to law school, today's youngsters are thinking about the world of opportunities in a very different manner, including the legal sector. And your law firm, in particular, such as some other law firms, have been richly benefited by the globalization of Indian economy. So if that you have indeed got those benefits, and now we are looking at the next generation of reforms in the legal sector, what is your timeline and your perspective to take the next step forward?
Like I said, principally, we are signatories to GATS. As a nation, we have taken a decision to globalize services, so we have no discussion there. Luckily, under the WTO rules, we can lay down the conditions and open them in a manner that works for everybody. Now, as a matter of fact, and I can go to our former finance minister, who I used to always jokingly say, and once or twice I've introduced him publicly, saying that we were the actual first beneficiaries of the liberalization of India, the lawyers and the bankers. When India gets the benefits, I don't know, but we got the benefits very early on in life. And 91 to now, there's been a massive, Sir has done some numbers, but if you look at the mapping of what happened in the field of law, it's actually mind-boggling. I don't think any other country, other than probably China, because during Tiananmen Square, they killed all the lawyers, they listened to Shakespeare, and they killed all the lawyers. And that built China up as well. But China does not have the quality even today that India has.
Indian law firms have gone and set up there.
Yes, yes. And we are collaborating with a few Chinese firms and some big ones. And actually, sir, the largest firm today is about 11,000 lawyers, dentons. So, now, coming back to the benefits and what we need to do. As at least our law firm, and I talk about a few others because we do meet, even though they think they compete, I don't. We do have a chat regularly. And we are doing a lot of self-development. We are doing a lot of our own training, internal training to build our skills in various areas. And we're doing a whole lot of exchange programs with different law firms from around the world. We actually have a Japanese lawyer right now helping us understand the Japanese way of working. He's not practicing law or anything, but he's helping us. We had a German lawyer who helped us do our systems. They came and did a whole quality. We are the first ISO 9001 certified firm more than 20 years ago, 18 years ago. It was all set. Try getting an Indian lawyer to become disciplined. I know that is not possible, even with me. So we had this German lady who was a lawyer, qualified, spent 2.5 years and whipped us into shape. Her pet name was Hitler. Now the timeline-wise, I think what needs to happen in my view, and I'm speaking just, this is only my view, we need to have, baby steps is one thing, but we need to articulate the blueprint. We need to say that these 7 things will happen, who's going to do them, If the Bar Council has to make some changes, when will they do it? It has to be legislative changes. By when will the bill come? Let's put dates on it. But let's at least start with exchange programs legitimately. Let's at least start with the, you see, when a market like this opens up and whenever there's a joint venture, and I've done many of them over the years, and it's almost like a marriage, you need to have a courtship. And that's the best part, by the way, I can tell you with experience. But, and then you need to have an engagement, and then you need to have a marriage. So you have to go through those processes. If you don't, you're going to have what happened, messed up in Singapore. Every single joint venture collapsed there. And they took 28 years after this kind of a statement was made. It took 28 years for Singapore to open. And two hiccups on the way. One, when the entire program failed, which is about 5 years ago, 5-6 years ago. Now they've got a new formulation, so we can learn from those mistakes. And I've actually given Sir a paper, exactly what happened, what went wrong, because the current Attorney General, who used to be a judge in the Supreme Court, studied with me, Justice Raja. And I sat him down and I understood the whole thing from him, and we can benefit from that.
Thank you so much, Rajiv. I have a question for Anu. Anu, it will be very helpful for many of us here to understand the international legal obligations, if any, that India has under the GATS regime, but also in terms of, the kind of institutional expectations that have been generated internationally, because at one level, we send powerful signals both under the WTO regime as well as in other institutions that we are keen to open up a number of things, including the legal sector. And obviously the legal sector is one of the last bastions of resistance of some kind. So would you mind articulating the status and also to share with us your perspectives of how your own evolution as a law firm, as a new law firm which is competing with the big law firms, and how that plays in the context of the opening of the legal sector?
Well, to actually just take on from what Mr. Luthra was talking about, the WTO does offer flexibilities in terms of the nature of commitments that any country needs to take with regard to any sector that it seeks to open up. Now, legal sector is one where, because of the nature of market, because of the nature of the economy and the opportunities that are here, that it is an extremely attractive sector for a number of right from the European Union, the UK, the US, in the negotiations with Canada, with Australia. They're all demandiers for entry into the legal market, and the reason is clear, because there are clear opportunities here. But the intelligence with which we need to act is to make sure that we capitalize on the opportunity that the trading platform offers, which is essentially to make sure, on the one hand, the calibrated approach which both Mr. Bhasin and Mr. Luthra have emphasized on, and the blueprint for which, as they mentioned, has been around for almost a decade now. So it's really a question of how do we prioritize and implement, and in the process, there is at one level what we need to do domestically, autonomously for Indian law firms. That's one thing which is given. But with regard to what we open up for a foreign country, that just needs to be done with a lot more deliberation in terms of what is the overall balance of advantages that we gain from the other country, which is at one level, I'm actually taking it beyond the level of reciprocal opening up in the legal sector alone, to really a balance of rights and obligations overall that we can achieve, whether at the WTO or in the many bilateral, and now we're actually negotiating the regional cooperation for economic partnership with the ASEAN countries, Japan, Korea, Australia. So these are opportunities which we really need to think through in a far more deliberate manner. There is an excitement in terms of opportunities, but I think that just needs to be calibrated with what we need to do stepwise. The points are there, but I think the entire process of sequencing it just seems to be missing somewhere along the line.
Thank you so much, Anu.
So,
I have one quick point.
Please.
The report I talked about, actually, I just remembered, Anuradha wrote most of it. So there's a problem with that, you know who to blame.
So I want to ask Pratibha, during the introduction, we discussed how you've worked in nearly half a dozen different jurisdictions. You've been with a large global US firm, and you've been with a major investment bank and now you're with an Indian firm, NDA, which has, of course, a presence across India, but outside of India as well. So can you just give us your views of how you see this issue and whether you think we'll be seeing changes in the legal services sector to the extent that you may want to see them in the near future?
Sure. I actually wear multiple hats when I speak. Let me talk about when I started off in the profession, and both Raj and I wanted to come back to India, but like a lot of our colleagues who started off at that time, we were staying in offshore jurisdictions and doing covering India from those offshore jurisdictions, because we were looking at the Indian market, a very closed, highly controlled Indian market, to see what are the opportunities for people like us. And a lot of our colleagues are still out there. There's a lot of talent sitting outside of India and covering India from there because of multiple issues, and let me lay those down. I understand the need for protectionism. I understand the need for developing Indian markets. People have spent a lot of time building firms, so I understand that they need time to nurture that. But from the point of view of the professionals who are in the market, a closed market leads to not having associates trained in a globalized environment to service global clients. We have great talent here, as Ambassador Verma said. I work now with, and worked for decades now with that talent, but they don't necessarily have the exposure, they don't get the exposure. That's what protectionism does. It's not just in the legal services, it's in all services, and we as pretty much all the lawyers on this dais work to get liberalization done for other sectors, right? So it's an anomaly in that sense that we've been pushing for protectionism in this market. Be as it may, when we decided that we needed to come back home, and I joined Goldman Sachs as GC because I thought that gave me that protected environment to work in and be able to give quality to service to my clients, which was in-house. It was really painful because it was still the same problem. You're not finding, your clients are expecting, your internal clients in my case, the same level of in-depth, I wouldn't say research, but a way of presenting, which exposure you have when you're working with a global firm, which works across jurisdictions and understands the language of a global organization like Goldman Sachs, where I was working. To get that kind of service from Indian firms, which has great talent but doesn't have that exposure, becomes extremely important. So you're wasting a lot of time translating, right, the Indian law to a global economy, and not having people who are able to do that. As a GC, as a general counsel, it's an extremely painful process. And now, being in an Indian firm, I see it from a young associate's perspective, and even from my perspective. Training your associates, right, is doubly hard when you are a Indian firm. You're not a global firm. You don't have necessarily, the precedents which take the benefit of international experiences. Your lawyers are getting trained in a very, very closed environment instead of a broader globalized environment. All those issues, I think, also need to be thought through very deeply, especially for this audience, for these young kids who are getting into this market. What are we offering to them and at what speed? I understand that we have to have level playing field for Indian firms. I am in an Indian firm and I would love to have level playing field. But the way we are dealing with it is, we've opened offices in 5 different jurisdictions across the globe. We have office in New York, Munich, Singapore, you name it. And so instead of saying, listen, give us a level playing field, we're going and seizing the opportunity and getting ourselves competitive, right? So, and I don't think that level playing field necessarily existed in all the other sectors that we as lawyers have pushed for opening up. You know, so it's a little, I would say, not fair for us to ask that, wait for that exact level playing field till the markets open up.
Thank you, Pratibha. I would now like to ask a question to Devaya. Devaya is a partner and general counsel of this Everstone Capital Advisors. He represents a different type of an institution, and I assume your institution must be seeing this entire debate in a different light. So, one of the questions that we will have is that, are you guys out of the discourse? Is private equity firms such as you, who are actually lawyers there, are you in any way involved in this debate, and do you have a position?
Well, first of all, I am not part of a law firm. The Bar Council of India does not have an oversight on me. I am neither a member of the society, so I can be very frank and talk my mind without a fear, except for Rajiv, who's sitting by my side. So at any given point of time, as a GC of a large PE firm, I am engaged with at least 4 or 5 domestic law firms in India and at least 3 or 4 international law firms when we do international transactions. Dealing with these 2 sets of firms, both domestic and international, is a completely different experience. I don't intend to belittle my brethren here, domestic guys, but certainly I think the learning curve which the international guys have is much more superior. It's not just about the content, it's the skill. Sometimes I see youngsters here in India, they may be very proficient with law. That's not enough. They don't have basic skills of communication, diplomacy, the right way of writing emails. So all of these soft skills will definitely have to undergo a sea change. From this perspective, I think the foreign law firms will play an important role in bringing that change. Indians are basically very intelligent. I mean, there's no doubt about that. So from this perspective, I think we'll be greatly advantaged by having these guys coming. That's my primary view. But I have that's my answer to your question. But I have a reaction to your question, which is slightly different. This is a country, I mean, most of the audience are from the student community, so I think I have the liberty of lacing my conversation with a little bit of academics. This is a country which gave the subcontinent universities like Nalanda, Takshashila, and various other universities. Jindal, yes, absolutely. 4th century BC, the Takshashila University had a law faculty, right? Students from Japan, Tibet, China, Korea, Persia, all these places came to study law in these universities in the 4th century BC. Kautilya was a teacher and a professor and a student in that university. Arthashastra was written there. Today, in 20th century, when we are just about to celebrate our 70th independence, we are talking about bringing in foreign law firms to improve our quality. Ironical, isn't it? Why has this happened? We are all responsible for it. Our policies are responsible for it. It's not just about bringing about foreign law firms to improve our quality by using the organic method. We also have to keep in mind this process involves an inorganic approach as well. Look at the law colleges in tier 2, tier 3 cities. They are in pits. Who's addressing that? How many people in this country can go to a college like Jindal? Have you guys seen the infrastructure with these tier 3 law colleges have? Have you seen the kind of the teachers who teach in these colleges? It's very sad. Thousands and thousands of lawyers are produced by these colleges. And then at the end of the day, if you say the quality of legal services is not great in this country, it is we, our policymakers, who have to be blamed. Have I answered?
Thank you so much, Devaya. For those of you who may not know this firm, Devaya's company, rather the private equity firm he's working is Everstone Capital. They have an assets management of over 3.3 billion US dollars. So it's a large private equity firm, which many of us may not be aware of. So he's the general counsel for it. Now we have the last panelist who has not responded so far. He would like to call himself as the non-Delhi voice here. Siddharth Raja is a distinguished corporate lawyer, and we were conscious to have him in the panel simply because most of the public policy conversations in this country are confined to people who are in Delhi, working in Delhi, and in many ways running Delhi and India. So Siddharth, you will just participate in the debate.
You crucified me even before I had begun. Let me say. But it's a point, I want to make 2 points actually, and that is, as you rightly said, if I can call it outside of the Delhi-Bombay vortex, okay? Outside of the Delhi-Bombay, although we are now 55 lawyers with 11 partners with a presence, significant presence in Bombay, headquartered in Bangalore. I'll tell you the non-Indian, from what I can sense of non-big law view on this is, actually speaking, in Bangalore for instance, a lot of our peer firms have either not even begun to think about this issue or have indifference, because the sense of Armageddon that some of these foreign law firms might bring is perceived as being very distant. I don't know how true that is, but the fact is that it is seen as being a little distant. Now, from where I sit, it's perhaps an opportunity for firms like ours, or more dramatically, bits of the firms of ours that might get picked up by foreign law firms who want to come in and raid, because that's what they'll probably do, they'll cherry pick and raid, is to ask a question which I think both Mr. Luthra and Mr. Bhasin are asking, which is that phase 1 is a critical precondition even to facilitate liberalization, even from an internal perspective, so as to be competition ready. Right? I think it's important, even from a perspective of a firm that might say, we are willing to consider talking to these firms. And the one aspect which is in a phase sequential manner that both Mr. Luthra and Mr. Bhasin are talking about is, again, outside Delhi-Bombay vortex, is simple issue of access to finance. We as law firms are not classified as being eligible to get a bank credit, a working capital credit. That means every rupee I spend has to be backed by a receipt. It's called cash flow. Which means that if I want to spend money on business development, I have to think 10 times, because it means actual cash out to be earned. If I now had, for instance, a line of credit which gave me the ability to leverage some debt, I have money, we've got to put money away month on month with a buffer, merely to make sure that every month we make payroll. And we've gone twice to banks, including our own clients, and they've refused to give us lines of credit. Because we're not classified as that. Doctors get lines of credit, chartered accountants get lines of credit, we should get lines of credit. That is an important aspect of this internal liberalization, and I agree with that. We need to be, in order for us to be enabled to get competition ready. I think the point was made that there are several policies out there which obstruct. I'm saying a bit of both, I think, at the end of the day. I think it's a good thing that's happening. But something is shackling us. Thank you.
So I just wanted to go back to this issue of, and we started off the conversation talking about this issue of reciprocity. And I know, and I know brought it up in Mr. Bhasin as well. But I wanted to sort of drill down on this and get a sense of what many of you here think about the issue of reciprocity and the extent to which you feel that currently under the draft rules, reciprocity is or is it not being adhered to under the new draft rules? What is it that you hope to gain in terms of access to foreign markets like the United States and Britain? Is it the idea of trying to get access to all 50 jurisdictions in the U.S.? So I was wondering if Mr. Luthra, would you mind saying something? Because I know you've worked on this. We talked about this just a couple days ago as well. Can you just give us your take on the issue of reciprocity and the extent to which you feel as though it's...
While reciprocity seems like a simple word, it's actually very, very complicated. If I try and explain this to you, what the issues are.
Please.
One, do we need reciprocity? Unfortunately, the current law requires that there has to be reciprocity. Only on that basis they will allow practice of law. Even people qualified, Indians qualified in a foreign law university, recognized by the Bar Council, and that recognition is based on reciprocity. Only then they will allow that. So that's one. So we need to amend that if we need to. Now, what does reciprocity mean? Scandinavians that my friend worked for many years has offices in 8 jurisdictions or 9 jurisdictions. Does it mean that if Scandinavians open an office here, all 9 have to have the same reciprocity with India? Only then Scans can come here? Or Baker has 60 offices around the world, 60 jurisdictions. How does that work? So then America, Ambassador Verma recommended that we can have this foreign lawyers go and practice anyway. Intra-America you can't practice. Between New York, across the Hudson to New Jersey you can't practice. So where is the globalized, where is this whole debate going in so many different directions? So we need to really first understand as a nation, what is it that we need? And what is the right thing to do for us? We should open? Yes, we must open. But the question is how and under what conditions.
So can I just quickly follow up, and this is for my own clarification. Foreign lawyers coming to India or seeking to come to India, they're not seeking, are they, to practice Indian law? They're seeking to advise on their own home jurisdiction or to practice what we might call international law. So the idea of Indian lawyers going and practicing in the United States, there are provisions, as you well know, for foreign lawyers to serve as foreign legal consultants. So I wonder if the issue of reciprocity, if we're in a way talking past each other, is it that, are you saying that Indian lawyers, because they're not able to gain access to practice American law in the United States, because that doesn't exist, we have to be cautious about letting foreign lawyers into India? Because after all, my sense is that foreign lawyers are more interested in serving in that foreign legal consultant role, correct?
Clearly understood. See, if you take it from what reciprocity should be everywhere. Reciprocity should be in visas. It should be, for example, if I want to set up a foreign law consultant practice in UK, I need to pay so many thousands of pounds professional indemnity insurance. I don't need to do that in India. Can I easily get a visa if I apply even to America to go and practice? No chance. I mean, we've had a problem with Pratibha's managing partner. He was almost thrown out of the United States of America, even after having been there 16 years. So, you know, it can't be just taken, you can't cherry pick and say, hey, we just want to come here and practice our own law, right? Allow us to do the same thing. We are fine. Right now you have allowed it. We haven't allowed you to come into India. But is that happening? Every day. Just go to any of the big hotels in any of the non-outside Delhi cities and you get the hotel roster. You'll see the foreign lawyers sitting in Oberoi, Bombay, Oberoi, Delhi. Oh yeah. We deal with them all the time. I know it. And you can look at it. It's happening all the time.
Mr. Pandey?
Before you answer, I wanted to push you on one question, which is related to what I'm hearing. No, Mr. Pandey, I don't push you. No, the thing is that what we are hearing from you,
Good point, sir.
what we are hearing from the law firms here, it seems, a few of them at least, and including self-position, seems to be that, you know, we need to create a level playing field. And you know very well that reforms in our country has not happened in a situation where we spend the next 5 years creating a level playing field, and then we will work for the next decade to see how we can open up. I am not sure whether the Prime Minister or the government is having that kind of a time span. In some ways, my question to you is that, has the government thought about the kind of, not as resistance, but important issues which both Mr. Bhasin and Mr. Rajiv Luthra are raising, which is that, you have not even allowed us to do many things, and now suddenly you're going to make the foreign law firms give them all of that, and what happens to us? What's your answer for that?
First of all, I would just like to build on the point Mr. Luthra mentioned, a very important point which is often ignored, and from GATT's perspective, it's extremely important. Domestic legal reforms in the governance structure, regulations, important. But what is equally important is principle of reciprocity is a very complex area, and as such you can never achieve it because of variety of reasons. But what you should be looking at, couple of things. Number one, the incorporation requirement, what we call mode 3, right? How do you incorporate a law firm in India? What does it cost? And how do you incorporate a law firm in UK or US, and how much does it cost? This is one. So when we are looking at governance structure, then we should be very careful that we provide for some element of balance so that the incorporation hassles and costs bring you at par. Then recurring costs. Now, the recurring cost of incorporated law firm in different countries are different. In India, actually, the analysis that we did compared to what it costs in UK, it's nothing here. You have to provide, if I am not wrong, almost 5% of the turnover as a renewal fee to the government. Third very important issue that Mr. Luthra raised is the visa. Now you incorporate a law firm, but if to man that law firm, your lawyers cannot fly in and be stationed there. We have seen a lot of protection around the globe lately, where the duration, kind of visa that will be granted, if it is denied, then you ultimately land up not rendering the kind of services that you were looking for. So this is extremely important dimension which we need to look at, and we have actually in consultation with a lot of people in the legal fraternity, we have discussed this issue, and it is possible to address some of these challenges. Now coming to your second question. Actually, we are not looking this in a linear fashion. The phasing is not linear, that this will happen when only this gets completed, then, because that is not going to work. And economy is getting impatient. Now, let me share it from a very limited perspective of government. Now, we have over 60 the investment treaties. We have almost 20 the preferential and free trade agreements, comprehensive economic agreements. We have a platform of WTO where disputes, issues concerning various countries, various economies, they come up very often. Now you have to have access to expert legal opinion, legal advice all the time. We don't have access everywhere and in every country. At times you are consulting your embassy in that country, you are trying to find out your local partner here, that whom with you can tie for the services in that country, and it's very complex. And then communicating makes the whole thing very suboptimal. So what we have in mind, couple of things should be done straight away without much thinking, which is largely relating to domestic reforms. The issue of we say in commerce market development tool, which is limited advertisement, right? And advertisement again regulated means you build around good regulation so that it is not misused. Then the nature of the law firms, access to finance. We are not talking of FDI, that you allow FDI. But if you don't have access to finance, then your other partner has access to unlimited finance. Now how do you compete? You can't compete. And fourth, again, connected with this very important size. Now, it is important that we have the size and how it will grow. When you will do all the three things, I am sure many Indian law firms would be in a position to scale up immediately, means without much problem, and it will happen. India in particular has tremendous power of resurrection. So it will be a little pain maybe in the beginning, but you don't have to wait. Everyone will bounce back and they would be in a position to readjust to the changed scenario.
Thank you so much, Mr. Kumar.
So I want to. Sorry. So I wanted to go back to another question that we opened up with, and this is really for anyone on the panel. The issue comes up repeatedly as to whether or not the Advocates Act has to be amended in order to allow for the registration of foreign lawyers, or whether that can be done internally through a bar council regulatory change. Does anybody have a sense of the feeling? Please, Mr. Bhasin.
See, the Bar Council draft rules,
Yeah.
I think as they are framed, is one of the most atrocious pieces of, drafting that I have come across. And if those draft rules have to be implemented, then there is nothing but a disaster. Because there is no clarity, they have not applied their mind, we don't know who is the author, who has drafted those, there is no committee, there has been no consultation with the stakeholders. Who are the stakeholders? That is basically the legal profession. Bar Council of India does not represent the legal profession, it's the regulatory body. It is a licensing authority which gives licenses to lawyers to practice law. It is not representative. Representatives are the bar associations all over India. Representatives are like organizations like the Society of Indian Law Firms who represent the interest of the law firm. They have suddenly come up with these draft rules. And you are saying amendment. I think so many amendments would be required if these draft rules become the actual rules and they pass the stage of draft. Because they say law firms can be registered. Now, Advocates Act doesn't talk about any law firms. Even Indian law firms are not registered. It is only the Indian lawyers individually who are registered as advocates under the Advocates Act.
Sorry, can I just follow up quickly with that? So does that mean if those draft rules are implemented, you anticipate an immediate challenge in court to them?
Immediate, these are counterproductive. You see, I don't see any issue, and I think we have slightly digressed it from the main issue as to what should be the timeline for introducing the so-called legal reforms. I don't see reciprocity and all as major issues. Reciprocity is inherent, it is implicit. We will definitely say, okay, if we allow someone from UK to come, then we should also have the corresponding rights. I think those procedural matters could be taken care of. What we are emphasizing time and again is, with which you see at least the government of India through the Ministry of Commerce, they agreed that there should be a phased entry. Now what is phase 1? Phase 1, as we said, is like a precondition to phase 2. Phase 2 is the condition where you see they are allowed to come and practice their law in India. But phase 1 has been totally discarded in the Bar Council of India's draft rules. And I'll just try to just read out to you. This is a part of the official report that we are submitting as to what phase 1 is.
Please.
Because Pratibha spoke about protectionism and all that. Now there's no question of any protectionism. We are not here to protect our turf. You see, we are not even talking about a level playing field, but we are saying that give us justice before you allow, you see, this grave injustice to happen. That straight away, as if, you know, if India got independence in 1947, you make a demand, open up your economy. But that could not help. We are at a stage, you see, at an essence stage, in 1901, our economy opened up. There were so many law firms which came up all over India that saw a sudden spurt, you see. We have so much of talent here available in India. And I again reiterate that we are second to none, despite, you see, what my friend Mr. Devaya may say. I think in our offices, in our staff, in our lawyers, we have the best talent available, including speaking English and even writing English and even writing emails and all that. We are, I think, very good at that. Now, the phase 1 is what we have been deprived of so far. Regulatory and administrative reform, recognition and removal of difficulties for practice in the LLP format. Bar Council of India clarification that practice of law in LLP is permissible so long as all partners are advocate, request pending since 2010. Income tax clarification, request made to CBDT in 2010, that is conversion of partnership firm to a LLP is not a taxable event. Then changes, entry and exit of partners, post-conversion permitted, and change in assets and liability post-conversion, these should be permitted. Then recognition and registration of law firms by BCI. Even in India, you see, they are not registering, but foreign law firms, they will register. And BCI rules to be amended to permit firm brochures, firm websites without restrictions placed on the content by BCI, directory listings, sponsorship of events, other means of market development, which Mr. Sudhanshu Pandey spoke about, market development, and information dissemination firm information including credential presentation, participation in bid out tenders for legal services, ceasing of all surrogate practice of Indian law in India by foreign law firms through various devices and structures, which is happening, which is rampant throughout. Then, pausing of practice of Indian law outside India by foreign lawyers and foreign firms. Websites of several leading foreign firms unabashedly claim India practice conducted through overseas offices. Ability of Indian law firm to engage foreign lawyers and so many other things. This is phase 1. Now, if we are serious about what when we can bring in the phase 2, it will not take even a month. Government of India has nothing to do with that. Government of India is fully supportive. It is only the Bar Council of India which has to take all these decisions. So why can't they just meet once and take all these decisions? It won't take a month and we straight away go to phase 2 then.
So
that is the timeline.
Thank you. Lalit, if you want to, please.
Just wanted to, add, it's really not at all about protectionism. I think it's really about being prudent in terms of having systems in place. It's not about closing doors. In fact, there's just so many dimensions to this debate. In fact, Ambassador Verma's intervention in the first part of the session was really, his focus was all about just removal of citizenship and then allowing foreign lawyers to qualify according to your own laws, which is different from what what the panel discussion is all about in terms of opening up the legal sector and having law firms coming in, etc. The other point I want to really emphasize is that we are really not alone in the nature of complexities of domestic regulations and qualification requirements, etc. Practically every country in the world has complex domestic regulatory mechanism for any professional sector, whether it is medical, accountancy, legal, name it, you have it. It's not a question of opening up a sector and then foreigners coming in and competing on same terms. There are very strict domestic regulatory requirements that are in place. So having them is nothing unusual, having that is nothing protectionist. It's just a question of being prudent and then also assessing what is required, whether it should be limited to foreign law and international law practice alone. At what point of time can a foreign lawyer qualify under Indian law by removal of the citizenship requirement? There are just different dimensions to it. I don't think there can be any easy answers, nor can it be brushed away by saying that, oh, Indian market is being protectionist.
Thank you. Pratibha, did you want to?
So, just to clarify,
Yeah, please,
you know, when you say protectionism, and which is, you know, a term you didn't use but implied, there is nothing wrong in protectionism. Let's be very clear about it, right? Every country has done it. We continue to do it in different industries, right? Just last night there was clarification for financial services. You know, it's been opened up a little more, but for years we've had, you know, protectionism for our financial services industries because we wanted our banks to have that benefit and have some time for having that level playing field before, you know, we let the global forces come in. The whole question of Indian economy being liberalized is we had a protectionist policy before that, and then we liberalized. So I don't want to go into semantics here, right? Like this is a small closed-door community here. So to me, the issue more is what is that time frame, right? Because from where I see it, because, you know, I've had those various hats, I've had the benefit of working in global firms where it's really helped me understand what globalization means, what service to big global firms means. So I cannot today, I'm sitting very pretty in a domestic Indian, one of the leading Indian firms, and I'm actually benefiting from you know, this being a closed economy. But I will be doing injustice to the benefits that I have received and not providing that benefits to the next generation in a more open manner than I did. Having said that, I understand all the issues that are being raised, and the right people are involved in you know, figuring out how do we do this in a phased manner, including, you know, our founding partner initiative. And I completely agree with all that debate. All I'm saying is, at some point of time, we as lawyers need to figure out, are we in the interest of protecting, you know, what we are trying to build, the institutions we are trying to build, affecting the Indian economy? Are we affecting, because if you talk to clients, they will tell you not having their trusted legal advisors, they're used to, so I'm not just talking about, you know, the Indian clients, but if you have a Google or an Amazon who's used to, you know, a global firm providing services across countries, not having the benefit of the same service here, right? Does that inhibit growth in India? So it's related to the broad debate of how much are we opening up India, not just in legal services, in all other industries. There's a policy around it, and that's the policy debate we are having today. But I just wanted to clarify, I'm not going into semantics, I'm not saying it's good or bad, I'm just saying as lawyers we need to decide what is that time, how much time do we take, as Mr. Pandey said.
1 month is the PCI.
Absolutely, sir.
So
I just want to just make one quick point for the youngsters over here. You know, there are various websites that say they print legal news. There's one sitting over there. And the comments really paint, especially Mr. Bhasin, which is unfair as a dragon. Now let me tell you guys what it means to a foreign lawyer can come into India and practice law. Let's assume that happens. But his liability is limited. We today practice unlimited liability. Now I want to convert to a limited liability. The The Bar Council has not agreed. Let's say they agree. If today my valuation, Mr. Devaya does a lot of these, what is it, 20x of top line? So if it's 20x, some NDA type firms will be 2,000 crores or 3,000 crores. Now 30% of 3,000 crores will have to be paid today. So 900 crores will be paid by Mr. Nishit Desai and his partners before they earn a rupee. Is that possible? So this is, this is completely impossible what is being suggested also. So they need to think through this. And Mr. Bhasin, I can tell you, I've known him for 30 years. Apart from being draconian as far as I'm concerned, he's not a dragon. Because he always regularly sends me mails and sends them to 50 other people. Thank you, Mr. Luthra, for agreeing to giving 5 lakhs for this purpose. And sign Mr. Bhasin. He does that all the time.
Thank you so much, Rajiv. We have a good 45 minutes for discussion, so we'll get back to the audience as well. I just want to ask Mr. Bhasin a very important issue which he's raised, which is the fact that the heart of opening up of the India's legal sector is actually not the law firms, not the government, it's all about the regulator, the Bar Council of India. And that's your observation. Now, if I were to push you on that front, you see the Bar Council of India, as you know, is governed by the Advocates Act, created the regulatory framework for Bar Council to regulate legal education, legal profession. There are 1,400...
Legal education.
Yes, legal education, legal profession. There are 1,400 law schools in India today, and these are all regulated by the Bar Council. Now, let me just ask you a question.
Most of them non-existent.
Yes, that's right. Now, the question that I really want to ask you is that, if you and self and Indian law firms believe in the fact that this is inherently in the best interest of Indian economy and Indian legal services to actually open up, should we not also consider a possibility that these reforms can propel the internal reforms that we are hoping for? In a way, what I'm really asking you is that, should we be waiting for a time when the Indian regulatory bodies such as the Bar Council, which will actually open up? Because, frankly, the question that I really have, and Anu also I want to respond to, is that in the higher education context, it does not happen. We have 22 regulatory bodies in India which are regulating higher education. The opening up of India's higher education sector has been talked about for over a decade. Nothing has happened. And today we have the Prime Minister's office promoting the idea of 10 public and 10 private universities. Why? Because they want to bring those 20 universities outside India's own regulatory structure, because they realize that within the regulatory framework, it is not possible to seek reforms. So I am seeing the same things emanating out of the legal sector. So is it possible for us to actually seek that reform through the Bar Council, or we need to look at alternative measures?
You see, the government of India took a very good initiative right from 2014, and now this is again gaining momentum as a result of the intervention of the Prime Minister's office. That is why a group has been set up under the Law Secretary to look into that. But for every step that we take, those may be baby steps and all that, we do require the cooperation, the coordination with the regulator, that the Bar Council of India. And at any given point of time, I have seen so many events happening wherever we say that so and so from the Bar Council of India will come and will speak on these issues. We have always seen that they never turn up, you see. And I can tell you that, you see, with some considerable weight at my command.
The only thing I would say is that the chairman of the Bar Council did mention that he is coming, but unfortunately he's not there.
In the larger context.
Please.
You have raised a very important point, and India as a country is actually struggling and has to look beyond. In 60s, largely around 60s, when by and large the profession, whether this is chartered accountancy or it is education, it is medical, dental, law, in all these professions, the profession became the regulator also. Now, if you see around the world, initially there was a similar kind of situation. But later on, the two functions have been separated. And these functions have been separated independently. Now, regulator in most of the developed countries now has become an independent body, which is at arm's length from the profession. Now, it may not happen overnight, but that is the only way to go forward. Because as long as the conflict of interest is not removed, a neutral, objective view cannot be taken by, because there would be different interest groups within the profession. They will rightly try to protect their own limited interest, but a regulator has to be independent, and therefore different models have come up globally. The 10-10 private and public institution. This is an experiment, and you correctly said that the education sector has not opened. But what it has led to? It has led to surrogacy in all professions. So which means you take, we were discussing the issue, say accountancy, right? Now consultancy, management consultancy is open in India, right? Accountancy is not open, but all big four, they hire a local accountancy firm, even though they get the contract. The local firm does the work, and you have seen the Satyam classic case. The auditor went to jail because the liability was not that of the big consultancy firm, because somebody else was doing work on their behalf. So in commerce, we very strongly feel architecture. Now I am raising a larger issue here. Now you have Indian Council of Architecture, and again there is a provision there which provides for a natural person to be a member of the licensing and the registration with the ICI. But if you go around Gurgaon, if you go around Noida, you will see French architects designing this thing, American architects designing another thing, Singapore architects designing another thing. How it is happening?
Including our campus was designed by a French architect.
And it has happened. So what is happening, one of the points that had come right in the beginning, it's a very important point, and we have to see the only way, again globally, the best way to go forward is that the natural citizenship requirement has to go. But what has to come in place is a very objective examination, equivalence of education, which means that you qualify what exam I prescribe for, in addition to, like Indian doctors, they go to US, they qualify for that examination. Now Indian lawyers go to UK, they qualify 2 different examinations they have to take additionally, and they are qualified. Our feeling is, by opening in this way, you are not going to be flooded with people from outside. Actually, you will be finding it much more convenient to go out, because then MRAs, mutual recognition agreements, they become much simpler for you.
Thank you, Mr. Pandey. Now we open it up for further discussions. We have 40 minutes. I request you to introduce yourself and ask a brief question to either one of the panelists or direct it to the panel. We will collect 3 to 4 questions at a time. I request the panelists to note their questions as well, and we will then have time for them to respond. We can do this a few rounds. We will have time till 8 o'clock. So please, anybody from the panel. Yes, sure. Thank you so much.
I'll answer your question. evening, sir. I am the LLM student of Jindal, OP Jindal.
Can you please keep your mic closer?
Yeah. I would like to ask about the question of professional indemnity insurance regarding if the client has been advised wrongly, how to go about that. Because even if the law firms come up and again to India, if we make a special rule for them, it will be difficult. So before that, we need to make something about the professional liability insurance. How to go about that?
Okay, all right. Any other question? Any comments, question? Please. Yeah, you have a question? Yes, sir? Yeah.
Good evening, sir. Even I am a LLM student. My question is with regards to the status of foreign lawyers coming up here. Since we have decided that there is an already existing category called advocates here, and we have given up the practice of distinction like pleaders, muktas, which was existing in the act before. So, aren't we ready at this status quo to give them the room for Indian laws practice as well? Thank you very much for the time.
Good evening, sir. My name is Surya Rajkumar. I'm in the first year BA LLB. So I don't know much about law, but I've seen you speaking and it was really interesting. I would like to ask you, what is the simple advice you would give to young aspiring lawyers as partners in leading law firms? That's all. Thank you.
Thank you for that question. There's a lot of wisdom here. Please.
I want to know from the other lawyers as well. We heard about the need for a legal ombudsman. I want to hear, as in, are we not too late to talk about a legal ombudsman? That we should have been talking about that like way before. Many years back, yeah.
It does exist independently.
Independently, but a proper
Like
blanket kind of
like banking
legal
ombudsman.
Yeah, something like that.
Yeah. Last, well, we can't ignore Kian Gans from Legal India.
Hi, quick question, or possibly two questions. One of them is from a reader. What do you think liberalization is going to do for young lawyers? And we've kind of addressed that already, in that they might get access to better practices from abroad and these kind of things. But especially to sort of managing partners in the audience, what is the worst effect that this will have on the future generation of lawyers if it's done incorrectly, or if it goes well? I mean, what do they have to gain from this? And I think this might be interesting to students as well. And second question is for Mr. Pandey, actually. I think we've kind of tried to get at it already, but does the Advocates Act need to be amended, or is it possible to do it without any amendment of the Advocates Act?
Okay. Can we start with Mr. Bhasin? You may choose to answer.
Which question I should answer?
Maybe the one which
okay, on ombudsman.
Or no, but maybe the question which Kian asked, if we get it wrong, what's going to be the worst scenario, and if we get it right, what is the potential benefit for the next generation?
Since a policy decision has been taken by all the major stakeholders that the legal services sector should be opened up, it's only a question of time when there will be a full opening of the legal. So our young students and then who become young lawyers, they would all stand to gain. I don't think there can be two opinions about it. All of us, even you see, with our interaction with our foreign counterparts, would definitely stand to gain. It will be a very healthy competition among the law firms, whether Indian law firm, foreign law firms, and that augurs very well for our young population of students and young lawyers. There will be more opportunities. Have I answered your question?
For the youngster, then as part of Kian's answer too. See, most places in the world, particularly America and now more so UK, law is no more a profession, it's become a business. So you youngsters have to understand that, well, till recently, in most firms, even now in India, we are still a profession. So there is there's a human touch to it, there's a family touch to it. Once you enter this into a corporate sort of system, then you leave the office at 11 o'clock, you better be there at 5 to 9 the next morning. So you have to look at all of those things. And my own assessment is, we're not going to get 5,000 UK or American lawyers come and set up shop in India. I mean, we don't have to go very far. Let's look at the rest of the world. Wherever the home country law firm was, wherever they've gone out, it's been 15, 20, 30, 50, 100 lawyers maximum outside home country. Other than Dentons or Bakers or DLA Piper, leave those three out, they have a different model. But look at all the other firms. So it's not that we are overly concerned that these guys will come and, yes, they will cherry pick, no doubt about that. Well, we might be happy with losing some of those good cherry pick people, because they won't know, we will know as family, where the good ones or the bad ones. So all in all, on balance, if it opens up, there will be competition. In some setups, this whole so-called slavery. Once I was asked this question by one of my young partners, a lady, and walks up to me and said, "Sir, I've become a slave." So I looked up at her and I said, "Beta, what is better, slave or employee?" "What do you mean?" You know how the girls get all rabid in 1 second. "What do you mean? How can a slave be better?" I said, "Listen, you must understand, an employee can be fired. A slave can only be sold. And if I can't find a new owner, I'm stuck with you. So just remember, probably better to be a slave." So.
Okay. Is there any other?
I would actually ask.
I was also going to answer his. Sorry.
See, there was a question.
It's in our draft rules. Haven't you seen it?
There was a question about the amendment to the Advocates Act. We have studied this with Mr. Bhasin, with the Department of Law. To be very honest with you, actually amendment is not required. Government has powers to make changes in the regulations. So even without legislative route, those changes are possible, and they can amend the rules. So no.
I would think so.
Can I? Sorry, just both for Pratibha and Raju. There was that question about future generations and what they might look to do to be a successful lawyer. And since you both come from very different backgrounds and perspectives, I would be interested in hearing what you have to say.
So I think I already addressed that. I think, increasingly we've seen technology play a very important role in all of our lives, and the legal profession is not going to be any different. You as a lawyer will need to understand what's happening. Globalization and technology has seen, the transformation of even legal services significantly. Today I don't need to advertise. Nishit Associates is known because of its research, and that's possible because if you Google, you don't want to get into that. Sorry, these are Punjabi jokes. But we are known because of our research, and so if you Google, top 3 searches will come up on any research issue you take up, and our firm's name will come up. And so, that just changes how you advertise. It's no more about putting ads in newspaper, right? So you've got to be at the cutting edge of understanding technology and law. It's not just about, what laws you're reading in the books. And that's where I think globalization helps, and globalization of legal services help. And that's why we've gone out and set up for, we opened a Silicon Valley office before we opened a Delhi office, because we understood the importance of understanding what is happening in the valley, because that's where the new technologies are coming from. So, whether we liberalize, we don't liberalize, you guys need to make sure you understand, how the world is changing very quickly around you, and stay on top of it.
From my standpoint, and the way I see it, I think advice to be a good lawyer, let's examine what are the pillars that make a good lawyer. One certainly is integrity. Second is ethics. And third now is technology. Once you have these 3 clear, and notice none of it is money. Money is a byproduct. The problem with most of you youngsters today is that I interview a lot of, not a lot of you guys, I do a lot of you guys too, and you intern with us. Your focus is money. Your focus should be, what are you going to learn? The first, I've been to many campuses, and they discuss, so what do you pay? I said, why don't you ask me what I'm going to teach you? That's the important thing. So you should be hungry for learning. Money will flow, believe me. I've experienced it.
Just anecdotally, listen, I over a decade ago was picked up and worked with an American law firm, which had a perspective that we will get to a situation where we will be able to open an India office. So let's look at building capacity. And it was a great experience. It's an old, as I was mentioning to Pratibha, old Los Angeles law firm, right? Not from the East Coast. It had its own thing, which is a very family concern. Right? I mean, the partner I was working with was keen to take me out for a cigar the moment he heard that I used to have an occasional cigarette. And because he wanted to go to a cigar. So to that, it benefited me immensely. Right? And I am grateful to that because I've understood a lot more of not just the practice of the law and all of the other points that we mentioned, but the way in which you actually help a client. And from the perspective of what you asked the question, what do they gain? Well, I think the world is there to be gained, really, right? The only point is that, like with everything else in terms of liberalization, it has to be thought through, right? And that thinking through, I mean, in a manner of speech, it hasn't been done quite clearly over here properly. So there is advantage. There's absolutely no gainsaying that fact, right? I mean, there cannot be a denial of that. And why should we deny it to the next generation of lawyers?
So there is, one piece of advice which I would like to give for those who would like to do in-house. In-house, I think, requires a little bit of a different skill set compared to a practicing lawyer, whether it is litigation or non-litigation. In-house expects, the spread of your knowledge is vast. Understand the business extremely well, because when we work with lawyers, we typically come across the situation where they don't understand maths, they can't read balance sheets. Wherever they can't understand, they say it's commercial, right? So that's a typical escape route for lawyers to say that it's commercial. So that's the fix people who go in-house have to have, where they have to understand the business extremely well. Rather than being a support to the business, they have to be a part of the business. If they are just support to the business, they get lost in the crowd. So that's for in-house.
Thank you so much. Pandit, I know you wanted to leave. I just want to ask one question to you which might resonate, and there are 3 more questions here. The thing which we have not discussed is that in some ways, is regulation going to be late for many things? There's an article in the Financial Times just a few weeks ago. It's a report from Deloitte on professional services, which is predicting that through artificial intelligence and robots coming into legal profession, we are looking at a loss of 120,000 legal sector jobs, high-end including. And I know that this is a matter of concern evolving. So in a way, what I'm really asking is that, is regulation always going to be late, as we have seen in many other sectors?
My feeling means from the kind of intense discussion that is happening in the government, the way things are moved. Mr. Bhasin has been very closely associated with all those developments. We have reached a threshold where I don't think the process can be stopped. The only challenge that we have today, that we should get it right. So we should get it right, that is the challenge, but I don't see this process getting stopped. And today's deliberation therefore is more, and when I requested you, that how we should get it right, that is what we should be immediately seizing. We should be interacting at various levels in the decision making, because this is coming and it will not get delayed. This is what my sense is.
Thank you so much, Mr. Bhasin. And we'll have a few more questions as well.
Just on the question of
Yes.
Just on the question of whether amendment is required to the Advocates Act, Mr. Pandey is absolutely right. When we started our discussions way back in 2014, followed it up in 2015, and the interministerial group which was set up, till that time we felt that no amendment is required to the Advocates Act. But if you have a close look at the draft BCI rules, and if those rules have to be implemented, first you need to Amenity Advocates Act. I don't have the time, but I have the material with me to point out that how these rules would be inconsistent with some of the provisions of the Advocates Act.
Thank you, sir. Rajiv, you want to respond to a few questions?
There were two questions that you left out, Mr. Arnab Goswami. One was on professional indemnity. I think you asked that question.
Yes.
So on professional indemnity, how it works is, till about 15 odd years or 18 odd years ago, nothing that existed in India. There was no insurance company that would allow you to buy or sell professional indemnity. I think our firm took professional indemnity insurance about 13 years ago for the first time. Now we are covered for everything, but we have to pay a very fat premium. But we're not covered for negligence. So now you know that word, and which way it can be proved and how it can go. You're an LLM student, I can see that. So that's the issue. Everywhere else in the world, or most developed countries, firstly in England, it is compulsory to buy professional indemnity insurance. So if you want to start to go there, it's what Sir was talking about, barriers of trade. If you come and practice in India, you don't need anything. If I go to England, I have to pay £20,000 a year. Apart from all this, almost £1 lakh rupees as visa fees. So if you look at all of that and setting up, of course, purchasing power parity, etc., we can go into various economic discussions. And Divaya, I have to tell you, I can read a balance sheet and do some economics. So that's a fact. That was one. The second was the question on ombudsman. See, today, the Bar Council is the regulator. The Bar Council is like Reserve Bank of India. Can a bank decide on certain policies on their own and try and fix without taking the Reserve Bank into account? Unfortunately, and Kian, if you quote me, I'll kill you. This is off record. Our Bar Council is almost defunct. We have no real, nobody is regulating.
Of course he's going to quote you.
Kian will quote me. Okay, we have a deal. Put Mr. Bhasin, so says Mr. Lalit Bhasin. So we have an ombudsman. If you have a problem with the services a lawyer provides, you can go and complain to the Bar Council. And technically, you should have a hearing and a solution of either cancelling the guy's license. But I think in the history of the Bar Council, it's probably happened 7 times. So, and I look at the Bar Council across India, they're about, and some statistics were, why don't you do an RTI application? They're under RTI now. And say how many complaints have been filed and how many have been done and what are the...
They don't respond that.
It is not fair to...
RTI.
The Bar Council of India is not represented in this forum.
Why not? They re-elected them.
No, but they are not here, so I would not like to go into that discussion now without the BCI presence here. Can I call upon Mr. R. Venkatramani, the Senior Advocate, Supreme Court of India, former member of the Law Commission of India. He has a question, and there's another question in the audience, and there's one more. So we will be on schedule. It's 7:40. We will wind up at 8 o'clock as we have promised, and follow with dinner. So I request all of you to bear with us.
Raj, there's no question. I mean, it's an intellectually stimulating engagement in the evening. I don't belong to any firms. I've not got into that culture. It may practice in Supreme Court. But from a distance, I've been watching slowly the development with great amount of interest and concern. With regard to the Law Commission, on some occasion we had this to consider this issue. But fortunately or unfortunately, for some of us who want to take the lead, the Law Commission was too reluctant to get into this question. I came to understand that the Bar Council of India had probably put a lot of pressure that the Law Commission would not get into the question. It was a very sad thing to happen to the Law Commission. But what I want to say is, we have got connected a whole lot of dots today. From legal education onwards, the quality of legal education, to reciprocity, and the level playing field. I think they all occupy a kind of a connecting link. You snap one, I think there is the whole thing snapped somewhere. You're not talking about a static model, you're talking about dynamic model to evolve. So I think, personally speaking, I wish to banish Bar Council of India from its regulatory role as far as legal education is concerned. And once that is done, I think the next step will automatically follow. I don't mind that the Bar Council chairman is not here. We are talking about a policy, the institution, involvement of the community of lawyers and legal education. And where are we going? I think the sooner the better. Bar Council of India, by a very big amendment in the Advocates Act, if it is taken out of the old purview of legal education, the next important step will take place. The next question is, I think we need to look at the amendment to the Education Act from all these angles. Not really whether to permit, outside lawyers, law firms, or legal, practice to come in or not. I think unless we look into the Advocates Act fundamentally from what it has failed to do for legal education, and after post-1992, what has it failed to do for opening up legal sector, not only in terms of corporate sector. Look at what is happening to our tribal areas. Look at what's happening in the whole red corridor. Where is justice delivery system there? What is the Advocates Act have done there? What is legal education done as far as those areas are concerned? I don't think we can close to our eyes to those very important concerns of our country. I think we're able to connect these concerns, probably would have taken the next step forward. Thank you.
Thank you so much. We'll have another comment there, right, please.
I just quickly want to say, sir, you'll be getting an email shortly from Mr. Bhasin and thanking you for agreeing to join the committee.
Yes, I'm Bitika Anand, and I think this is also further to what Mr. Luthra was saying. I think we are talking a lot about these foreign law firms coming and all that. I've met many of them in the past 1 year in US and UK. Foreign law firms are very particular about their profitability and per partner profits that they make. So, and the kind of fee structures they have. So we may be here imagining, I don't know, when the opening is going to happen, there will be a rush of foreign law firms. Like he said, it's not going to happen. Because many law firms told me very clearly, Bitika, if I am going to get more in Japan, in Korea, why should I go to India? So these people, and they like to maintain their profits per partners. So it works like in a very different way, the way it works in India. So that is one. So that is a very important thing we should keep in mind in the whole perspective of getting to wondering, what's going to happen to us if there's a rush of law firms. Nothing like this is going to happen, like he said, unless they come under the Swiss Varan route, which is Dentons and Baker McKenzie's and all, because they have a very and they take a local brand and they open their firms. So I think this particular aspect is very important to look at it. We shouldn't get like two kind of, one is of course we should work on those things, but this is a very important aspect.
Thank you. There's another question. Yeah, please. Or a comment.
Well, good evening. I'm Sahib Singh Sidhu, BLLB first year. I was listening to the speakers, the distinguished speakers, and I made out that we've been talking about the law firms competing with each other, the ones from India with the ones from the foreign countries. But what do you think would be the impact of the opening of India's legal services sector on the advocates who practice law individually outside a firm?
Thank you for that question. Please, here.
The Bar Council is involved at the moment with the verification of the lawyers.
Can you please introduce yourself?
I'm Rahul Chiefness. I practice law including in Supreme Court. I used to be secretary of the Bombay Bar when I was in Bombay, so I interact a lot with the bar associations as well as the Bar Council of Maharashtra. At the moment, the Bar Council is involved with the verification rules. As you know, everybody has to verify that they are a lawyer. So in that sense, the Bar Council does not know how many members it has to start with. Yeah, and that's taking a long time. Then there come the elections. So what is this, I want to question to Mr. Bhasin, what is the steps that the society is taking to push, in that sense, the Bar Council to take steps to take reforms? Because the Bar Council is still be totally in a mess, to put it politely.
No, you're asking a very awkward question. We can't be pushing the Bar Council of India. It is the Bar Council of India which will push us out. They say, what is your locus standi? You are not even registered with us. It is only the individual lawyers who are registered with us. And we have taken up this issue with the Bar Council of India, which has been pending for the last 5-6 years, that you have some mode and manner, you see, of registration of law firms. But now they are coming up, you see, with a proposal that foreign law firms, they need to be registered, they will be entitled to be registered, but Indian law firm will not be entitled. So we can't push them anyway. It is only the government and Mr. Pandey who can push them to some extent.
But listen, we cannot forget the fact that the Bar Council of India was at the vanguard of legal education reforms, establishing the National Law School of India, University of Bangalore, and since then the 20 other law schools. So it's yeah, I know. So the point is, it's very
Law school at that time. So that is not happening now.
I think Bar Council
No, and rightly, Swami Sabat, Raj quite clearly said, played a very important role in regulating. And that sort of was a Freudian slip.
No, it doesn't. I mean,
but let me answer this.
Fair to the Bar Council of India.
No, they're my regulators. Yeah, I should be more scared. Oh, they're your regulators too. I just forgot. No, that's right. So,
scared.
I'm just joking. That youngster over there, first year BA LLB, his question was, what happens to you guys who are not part of law firms? See, the discussion is not about rights of audience. The discussion we are having right now with the Bar Council and the government, nothing to do with appearance in court. So if the foreign lawyers do come into India and do practice, they'll be only doing non-litigious practice and practicing home country law. So they won't even be practicing Indian law. That's not even contemplated, even if you read the first paragraph. But then when you go in, when you deep dive a little bit, the whole story becomes a pig's breakfast, as Mr. Bhasin said.
Thank you. Is there any? I think there were a couple of other questions. Please, Mr. Pandey.
So you raised a very important point, and recently this has happened with the Drugs and Cosmetics Act. Means when the government went through the whole list of about 240 amendments, then government, the group of ministers felt that bringing in so many amendments is going to confuse the law more, and therefore there is a time which is now to come up with a completely different law. So rewrite the law, and I feel that for the Advocates Act also, that stage has come. So rewriting of the law is a better option than actually amending the law.
Give you a quick example, guys. Income Tax Act 61. Read section 80. It started with section 80. They kept trying to plug. Today we have 80A, 80AB, 80VVA. Now they've plugged 19 loopholes, but they've opened up 64. So that's what the problem is when you just try and do band-aid solutions.
Any other panelists would like to react to any other questions? We're just moving to the end. I know there are two more questions we will take, and then we'll wind up. Yeah.
Maybe
we are on schedule. 10 minutes to 8.
So, if the reform of the Bar Council of India, this is actually a question, and I'm probably asking it myself. If the reform of the Bar Council of India and the Advocates Act, or the complete rewriting, is not going to happen in this form in a reasonable period of time, I think I've heard it being said that the liberalization, as in the Greek Bar Council rules today for foreign lawyers, will happen. It will happen because the two are not linear. Is that what I'm hearing?
That's Mr. Pandey did say that. That's the government.
Yeah. See, my understanding is the way our government is working, because see, the economy cannot address a number of issues which are coming up every day, because you are moving at a very fast pace on FDI, on various treaties, international agreements, and therefore access to quality legal service and whole range of legal service has become a necessity. So it cannot hold on like this, and therefore it has to change.
Thank you. We'll have the last two questions, please.
Just gonna quickly say, sir, I totally agree with you, but also having seen the liberalization till, for the last decade or so, this group here, we always comment on when, liberalizations is about to happen and how the rules should be written, and we always almost get ignored in terms of the fine print. I would say, you know, it's very important that here that fine print is taken care of, because
should I respond? No, except that, sorry, just before that, except that what I'm again hearing saying is that we will muddle through. We will get there sooner than the rules will change. We'll muddle through.
See, the problem is that this discussion will happen if somebody takes the responsibility of putting a complete paper, a comprehensive paper as to what the roadmap should be, right? That can be immediately be part of the discussion. But if we leave it like that, I will tell you.
This is the Bar Council rules, this is what they're right and why they are wrong. And this is what they should be drafted.
He wants a roadmap, not just for this.
Yeah, overall.
Everything.
No, for education. No, not now.
Well, I think we should get the
So thank you very much.
Let's get the
All right, we'll have a couple of questions. Pallavi from Bar and Bench. Pallavi from Bar and Bench. We'll collect those last three questions. Yeah.
My question is to Mr. Pandey. When you opened the discussion, you spoke about communicating with stakeholders is very important. And you said we have 1,200,000 litigation lawyers who are concerned about coming off foreign firms. To which BCI chairman also reacted and said that the state bar councils are very upset with these BCI draft rules, and they're trying to put it across them. So when you talk about communicating, how do you plan to bring all these people?
Bar Council called you and told you, Chairman?
No, I asked the chairman. I asked him separately.
I prefer.
No, because he mentioned about communicating.
Because he also.
Just a minute, Mr. Pandey. Let's collect those couple of questions. There's one more there. Yeah. Please. You'll quickly introduce yourself and ask.
Yeah, I'm Dr. Vijay from Indian Institute of Corporate Affairs, and from an academic point of view. Yes, I was just wondering that we are talking about Bar Council. Now it is through legislation this body is there, and this is represented by elected people from the bar itself, right? Now, how does it happen? Are we talking about a situation wherein there is an elected government and we are trying to have another government with or another committee like that? Because one has to seriously look into it, because that body is our body. We have elected that. So we have to think about that particular process itself, and that cannot happen without the act and without changing the process there. This is one point which I wanted to make. Another is regarding, we are talking about noble profession. I studied and I started my career, I started my career with a lecture by one of the renowned lawyers in Nagpur. And he said that our profession is a noble profession, and we wear the robe, and at the backside there is something in which the money is put by the client, and we don't charge. Now, if we are allowing this particular foreigners to come in our country and do this particular practice, where we are drawing this particular line? Either we are moving towards corporatization of that, or we are telling them to become a professional in our act. So these are the 2 points which I wanted to make. Another is regarding regulation, effective regulation. That is the last one, sir. The effective regulation we are talking about, and it has been pointed out already that Bar Council has till now have only 7 people debarred. Similar is with other professions like ICSI, ICAI, and other professional bodies. What we are doing about that? That is the thing which I wanted to. Another opportunity which is opening is in the form of insolvency professionals, which we are talking about in insolvency court. Now that is something which will again raise another issues as far as professional code is concerned, because new board is being made. This is a new profession which will come up. How we are going to handle these particular matters?
Thank you so much. There's a last question out there, and then we have the panelists respond to this.
Hi, good evening everyone. I'm Mehak Kocha and I'm pursuing my LLM. And my question is, so as a law student belonging from a private institution, what would our future be in this country where NLUs are preferred over the private institutions?
Great question.
That's a good one.
Great question.
Rajiv, that's for you. Rajiv, that's for Rajiv. But anyway, others should respond to the other question as well.
Okay, go strong here, take it.
We have been so democratic, and how can you compare?
I know. It's not exciting enough for me. So, your question was on ourselves, judging ourselves.
Right.
See, so there's one thought, yes, you're right, that the way the Bar Council is structured, there are people elected and nominated as well, by the way. The state Bar Councils are first elected. Then they elect the Bar Council of India. It's a bit like the Rajya Sabha and the Lok Sabha. Now go back and see, so one idea is that should the profession regulate itself through this selection process, because you have your friends, your etc., or should somebody completely outside come and regulate? Now either we bring a service like I mentioned earlier, like the Reserve Bank of India. Well, some of them are bankers, most of them are not. And there's a proper Reserve Bank of India, like an IAS, a service. Either you build that. Why do lawyers have to regulate lawyers currently? Because there's no such institution. Secondly, if you're not a lawyer, you will not know what the law is. Thirdly, the Supreme Court of India has very clearly said that only a lawyer can interpret Indian law. Now, if you add all of these together, you're stuck with the Bar Council. Now we need to figure out a way of making that organization work at least until then. I know it's not going to happen overnight, but until then the Bar Council should start taking action, should start putting things on the website, putting things transparently, complaints, not complaints only, but at least there's been a recent order that they have to publish the disposal of complaints and what happened. So all of that needs to be done. Regarding your insolvency thing, yes, it's a new area, but a lot of us already practice insolvency law. Not under the current act, but under the SARFAESI, etc., etc. So a lot of firms do that already. And the specified, the valuations and the valuators and all, they're already there, but in a different profession. So that will be easy to set up. There's not a huge opportunity from that standpoint. What was the other question? There was NLU and Jindal. Come on, there's no comparison. Jindal is far superior.
Any other responses? Any other panelists would like to respond to any other questions?
See about the powers of the Bar Council.
Can I request silence, please?
Bar Council of India spoke about. The remedy is to see what Mr. Sudhanshu Pandey said, that there should be to start with decentralization and decontrol of the regulatory powers of the Bar Council of India into different sectional regulators. For instance, there should be a segregation of regulator for the litigation lawyers. There should be a segregation for regulator for the law firms. There should be, a regulator for the in-house counsel. There should be a regulator for legal education. All these are now combined into one. They have got, supervening and extraordinary powers to deal with the legal, not only the legal profession, but even, with the legal education. So this has to be decentralized. And Mr. Pandey gave examples of UK and all, how this has been done. And actually it should not consist of lawyers, these regulators. There should be some experts from other fields. So that is the, I think, way out. Yeah. And lawyers or some retired judge or something like that.
Jay, before I propose word of thanks, would you like to give some
Yeah,
concluding
well, I just
remarks?
want to first say thank you to all of our panelists as well, and thank you to all of you for coming tonight. I think we made a lot of headway in terms of the discussion to date, and I love the fact that we had a very diverse set of voices here. I wish we had more time, but there's a lot of food that needs to be eaten, so I'll let Raj just say.
I really would like to thank and applaud the extraordinary contributions of our distinguished panelists for their presence. You cannot imagine the time that they have given us. Most of these lawyers are charging huge amount of dollars per hour, and for them to be present here and doing kind of non-billable work shows their commitment to public service and their commitment to be involved in some of the most important public policy issues. So I'm really grateful to each one of you for being present there. I'm also grateful to the distinguished ambassador for his presence and participation and taking off some of the key issues. I'm also thankful to our collaborator, Professor Jayanth Krishnan, as well as Indiana University Maurer School of Law, Christiana Osho, who is present here, my other colleagues and faculty members from the university who are present here, including Professor Stephen P. Mark from Harvard University, who is a distinguished member of the governing body of the university, the faculty members of Jindal Global Law School and other schools within the university, the administrative staff, Professor Anuradha Sethi and Mohit from the Career Development and Placement Division, Sridhar Patnaik from the Center for Postgraduate Legal Studies, and all the wonderful students who have taken this extraordinary ride from Sonipat to come to Delhi and to be in this discussion. So thank you to all of you. We will continue this discussion. I believe that this conversation was one of the better conversations that we've had in relation to this issue, particularly because of the diversity of voices that has emerged here, and that's because of the patience and the humility in which the panelists engage with this issue. So once again, thank you to all of you. Before you leave, we want to present a memento and a token of appreciation for each one of you for your participation.
A big hand to the 2 law schools who have made this possible.
Stop.